My name is Yobe. I'm a development consultant, author, and public affairs analyst. Well, I think it's part of our democratic culture. It's a split decision of 3-2, similar to what happened in Osun, where you have a majority decision of 2-1. And well, it's an established culture in judiciary that majority opinion will be the recognizable one. This decision coming barely 20 days, or less than 19 days actually, to the next general election. It's timely, although belated. I would say it's belated. But when you look at the crux of the matter, it's just to establish party supremacy. Recall that even Ahmed Lawan, as the president of the Senate, decided not to pursue this case again after he lost at the Court of Appeal. But the party, the All Progressive Congress, decided that they will pursue this to the logical conclusion. Now the logical conclusion has come. And you could say it's a technical decision, but technicality is also part of law. What the court is saying, or what the lordship, the three justices that gave favorable judgment to President of Court of Appeal and APC, is saying is that the party primary that was held on May 28, 2022, did not follow due process and was in breach of electoral 2022, because in their own words, the person who conducted that primary was not recognized by the National Working Committee of the party. However, they did not deny that he is a member of the National Working Committee. Now they are claiming that the one that was done on June 9, 2022, in which case the president of the Senate, Ahmed Lawan, was the clear winner, is authentic and the one that the party believes should be recognized. So what the Supreme Court has done is to actually recognize the supremacy of the party. However, their lordship, Justice Agbim, Emmanuel Agbim, and the other justice who disagreed, said, there was no cancellation of the May 28 primaries for Yobe North. And because there was no cancellation, there is no way you can have another primary. But when you look at the whole scenario, it will be, as I've said earlier on, that the Supreme Court is differing to the wish of the political party, given the fact that as their lordship has also on many occasions ruled, both in Rivers governorship and Kogi governorship election, that when people vote, they are voting not for the candidate, but for the party. And if the party says the earlier primary that was held was done in breach of the Electoral Act, and they have been able to convince their lordship at the Supreme Court that the current one, the June 9th, 2022 primary, is the one they want to recognize. I think it's just in order. But this has tendency to cast aspersion and doubt in the minds of average Nigerians who sees this more as a technical than legal issue. Because people have read some meanings into the fact that in one breath you cannot contest for two positions in the same election. President of the Senate preferred to run for presidency, but having lost us, he decided to go and contest again. It then means that he's robbing other people opportunity to have fair contest. And this has happened in many cases ahead of 2023 election. Recall the case in Ebonyi, where the governor also contested for the presidency and lost, and now went back and picked the senatorial ticket. The same thing with in Akwa Ibom, where the former minister of Niger Delta, Minister of Niger Delta, Gospel Akpabio, lost in the presidential race, only for Supreme Court to also recognize that the primary that produced him, even though was allegedly not monitored by INEC, is valid. I think that we can say, because it doesn't follow certain public opinion, then it's not sound in law. Law can be technical, law can be logical, law does not always pander to public opinion. We must know that. And election dispute resolution is a global practice that is not peculiar to Nigeria, and we will continue to have that. Of course, some reservations have been held that what we now have is democracy by court order. But judiciary is one of the institutions of democracy that is globally recognized. And to that extent, we cannot say we don't want judicial interference. We just need to appeal to their lordship to always do what is right and to do substantial justice and not just give, judgments that may not stand the test of time.